Well, good morning, folks. Got a few people on. We're just waiting for a few more people to fill up our from the waiting room, filling up. We've got, I think, over 180 people registered for today. So good morning. Hope everyone's doing well on this New England Wednesday. What better day to talk about unemployment, right? Like I said, we'll just give it another few minutes. The waiting room is filling up and folks are filing in, so it's good. As you can see from the backdrop, I have lots of volumes of incredible learning and experience, but Abby doesn't have any. And the reason for that is she's much smarter than I am. She doesn't need the books and resources. I forever have to reach back and pull something off the shelf, but Abby knows this, especially in the area of unemployment issues. Abby is, in fact, while the United States doesn't have any established royalty, I would unofficially, of course, deem Abby to be the queen of unemployment law in New Hampshire. That being said, that is again an unofficial title. So, but she is here to answer questions. So good morning. My name is Jim Reedy. This is She and Finney, and we are the proud hosts of the New Hampshire Tech Alliance. We've been working with the Tech Alliance, gosh, back to when I had hair. So back to the early 90s. And this is the HR Exchange. And it's something that during COVID, like a lot of other meetings, we went virtual. And our hope is in the fall and maybe even this June to go back in person, but certainly this fall back in person in our offices in Manchester. In the meantime, and actually at that point, we may also have a virtual presence as well, in addition for those that can't make the travel into Manchester. In the meantime, we're thrilled to be here with you today. A couple of quick housekeeping items. One is that there are HR credits for this program. That will be a slide at the back end of the materials. The materials will be provided to you, and Kelly Trudell, our Director of Business Development, will be giving you information in that regard and responding to any questions you might have. And yes, you can ask questions through the Q&A section in the materials, or online rather, so you can do that. And that's at the bottom of your screen. But otherwise, questions will be answered by Abby largely, and then to the extent necessary by myself at the end of this program. We go from typically 8:10 till 9:30, but there's no set time. So we could end earlier if we've gone through the materials and your questions, go a little bit longer if necessary. But so that's the HR Exchange for this month. This is the month of April, of course. In May, we typically don't have an HR Exchange meeting. We do them every month except for the month of May, because that is the high season for HR events. And I'm thrilled to announce that this year we're back in person for our 34th annual Labor and Employment Conference. It is on the 26th of May, the Thursday before Memorial Day. That's our typical landing spot for that. And it is at the Castleton Banquet Center in Windham, New Hampshire. For those that have been there before, it's a terrific site. Kelly found that site a few years ago, and it's been an ideal location for us. And we're going to be talking about lessons learned and adapting to the new workplace normal. And what, of course, we're talking about is what we've experienced in the last 2 years. But then it isn't necessarily COVID centric, because we're going to be talking about other things, whether it's technology or processes and programs. So that's what we're going to be talking about. It's wage and hour, it's paid leave, it's labor issues, traditional labor issues under the National Labor Relations Act. It will be data privacy and remote work and so on. And it's a half-day program with lunch provided. We hope you can attend, and of course, it will also have HR credits for that program. I understand from Liz Tezik this morning that, because we're coming out of what we've come out of, we're limiting the density of the program. We often have more than 325 people in that room. That's pretty tight. So we're limiting it at about 200 this year. So there's plenty of leg room, plenty of space. And so we have only about 20 spots remaining. So if you're interested in registering, you can go to our website under the events banner and register. And I would encourage you to do so sooner than later, because we are filling up and we do have to cap registrations. And again, that's more than a month away. June 8th is the end of the program year for the Tech Alliance HR Exchange, and that's when we do sort of a year in review, and that will be again virtual. And then we take the months of July and August off, and we're back at it in September. So it's often said without further ado. I don't know what ado means, even though I had 5 years of French. So I'm going to just simply say that it's my pleasure to introduce Abby Martignan. Abby is an associate in our litigation group here at Sheehan Finney. She's a good friend, and I believe, and most people believe here at the firm, an excellent lawyer. She's been slotted and dealt a lot with unemployment issues, but her practice goes far beyond that. In fact, at our May seminar, she's going to be talking about wellness and mental health issues, which were both largely ignored during the pandemic and certainly need to be addressed in the workplace for purposes of retention of skilled workers. But Abby has an enormous amount of experience dealing with unemployment issues, both in the normal course, but also with regard to the unique issues with COVID and COVID-related relief. And so she's here to sort of, in some ways, demystify the process. And a lot of you HR professionals have experience, certainly, with employees applying for unemployment benefits and perhaps going through the appeal process and so on. But still, a lot of questions, even from the most seasoned HR professional, there are still questions that remain. And Abby is here to walk you through that process and answer those questions. So please put your virtual hands together and welcome Abby to talk about unemployment in New Hampshire. Now, by the way, of course, our standard disclaimer is this is a general presentation for education purposes only, and it is not a substitute for specific legal advice to your circumstances. If you want that specific advice, we're always available to talk with you. But in the meantime, please welcome Abby.
Excuse me. Thanks, Jim. Welcome, everyone. I see that we currently have about 75 participants. We're glad to have you here this morning. Sorry we couldn't provide coffee and donuts, but I hope you have some at home. So today, what we're going to do is I'm just going to try to give you the 10,000-foot view of what employers need to know about the New Hampshire unemployment benefit process. As you'll quickly find out, this is a very statutory-based process, and the statute itself, if you were to look at the PDF that holds it, is multiple hundreds of pages long. And so we're really not going to get into the weeds here, but I hope that this will help you, at least, as Jim said, demystify the process. So what we're going to do is talk a little bit about the past as we move forward, as we try to get back to normal. We're going to look at whether you are subject to the unemployment law, because you may not be, but you probably are. We're going to talk a little bit about benefit eligibility and how an employee becomes benefit eligible. Then we'll talk about the appeals process. And then we'll just look at some helpful resources that I have been helpful in my practice, and I think are helpful for any human resource professionals who are trying to drudge through this unemployment process. And as Jim said, feel free to ask questions as we go along. We'll collect them all at the end and hopefully answer all of your questions. So as I said, we're trying to get back to normal, and I put ish just because we're still not really normal, and I don't know if we ever will be. But when we were going through the pandemic from March 2020 through September 6th of 2021, employers and employment agencies were really focusing a lot of their unemployment efforts on these federal unemployment programs. You have the Pandemic Unemployment Assistance, which was a federal-based unemployment that provided at least $168 per week of benefits to people who lost their jobs due to the pandemic, but who would not have normally been eligible for state unemployment. These people could include students, independent contractors, self-employed individuals, and other people who may have been disqualified for one reason or another from state benefits. And then we also had the federal pandemic unemployment compensation. And you'll see that there are a lot of acronyms with unemployment, so I try to write them all out for you. FPUC provided an extra $600 per week of extended benefits for, excuse me, hold on 1 second. For anyone who received at least $1 of unemployment, either state or federal, from April of 2020 through the end of July of 2020. This was a shortened period of benefits, but it still provided a big impact for people who needed it. Then we had the Pandemic Emergency Unemployment Compensation, the PEUC, and this was a form of extended benefits for people who had exhausted their regular benefit year, but who were still unemployed due to COVID. Lastly, we had the Lost Wages Assistance Program. This provided an extra $300 of benefits per week in August and September of 2020 for anyone receiving at least $1 of benefits. And it also extended in 2021 as well. Oh, thank you, Jim. Just brought me some water. So nice. So employment agencies are still dealing with overpayments of these benefits because if these benefits, the federal benefits, were overpaid in error, they must be repaid to the federal government. But you shouldn't be seeing employees receive benefits with any of these acronyms anymore, as they've all expired. So are you subject to the unemployment law? Let's start with the basics. You will quickly learn, as I pointed out earlier, that you'll be able to navigate whether you're subject to the law by looking through the statute. And there are two categories of entities that are subject to all or certain portions of the law. These categories are employing units and employers. So an employing unit is an individual or organization which employs one or more workers at any time. You can see that that's a very broad category. If you employ one or more worker at any time, you're an individual or an organization, you're qualified as an employing unit. And if you are an employing unit, you must retain certain records. All employing units must retain payroll records for inspection by New Hampshire Employment Security, that's NHES, for at least 6 years. Now, an employer is an entity that is subject to tax liability under the unemployment law, which is RSA 282. And an employing unit becomes an employer when it meets any of the following conditions. You can have one or more people working for some part of the day in 20 different weeks in a calendar year, or you pay wages of $1,500 or more in any calendar quarter of a calendar year, or you pay total wages of $1,000 or more for all household employees in a calendar quarter. These are just 3 of some of the conditions. There are other conditions that make you an employer as well, but I just wanted to highlight some of them. But the important part is that an employer is subject to tax liability under the law, whereas an employing unit is not. And just note that an employer, it does not include independent contractors or self-employed individuals. So there are certain filing and reporting requirements for employers that you want to keep in mind. There's an employer status report that must be filed within 30 days of first providing employment in New Hampshire. There's also a new hire reporting form that every employing unit, not just employers, must report all new hires to NHES within 20 days of the date of hire. Employers are required to post and maintain a notice to workers related to their rights and obligations under the law. Those notices you can get, and all of these forms you can get on the Employment Security website. And then lastly, employers are required to file quarterly tax and wage reports to notify Employment Security about the wages that have been paid and the taxes that should be paid. So if you're a New Hampshire employer, a new one, or someone who has just transitioned from an employing unit to an employer, you want to register as a New Hampshire employer with New Hampshire Employment Security. This is just a snapshot of the front page of the registration website to register as an employer. You'll see that each tab after the welcome shows every step in the process of registering. So you want to make sure you have all of the information ready to go as you go through this process. And there are also certain phone numbers that you can call at Employment Security that we'll talk about later on that will help you go through the registration process. So benefit eligibility. This is one of the bigger topics that I think a lot of people try to understand because it really affects almost everyone. If you lose your job, you want to know that there are benefits eligible to you, or the reasons for why you wouldn't be eligible. And for employers, you want to know if someone leaves, if you are on the hook for their unemployment taxes and for paying them unemployment benefits. So the basic idea behind eligibility is that if a claimant loses their job through no fault of their own, they should be eligible for benefits. So if they were laid off due to insufficient work, or there were not enough hours for them to meet their normal their weekly goal for hours, then they should be eligible for benefits. But there are also a number of other reasons why you may be eligible. If you voluntarily leave your job, you're normally not eligible for benefits unless you meet certain criteria. One of those criteria would be that you left your job for a bona fide offer of employment that might have fallen through, or you left your job to travel to a new location because of your spouse's career change. That would also make you benefit eligible. Additionally, if you leave your job for good cause attributable to your employer, that could make you benefit eligible. And so when you receive benefits, you have to not only be eligible in the sense of the reason for why you left, but you also must be monetarily eligible. And so a claimant must have at least 2 quarters of income in employment of at least $1,400 or more to be monetarily eligible. And if you meet that eligibility requirement, then NHES will establish your weekly benefit amount. Now, this might seem staggering to some, but the minimum weekly benefit amount is $32 per week. It's one of the lowest across the country. And the maximum weekly benefit amount is $427 per week. And this is just based on your income and there's a sliding scale, but you max out at $427 per week. So if you were normally making $2,500 every pay period, a $427 per week benefit may not cover all of your needs. So it's just something to keep in mind. And it's a policy perspective that I think everyone should just keep in mind. And then you're only eligible for up to 26 weeks of unemployment. And so in order to continue to be eligible for unemployment, you must maintain your eligibility. And that means you must continue to be able and available for work. You must search for work, and you must file your weekly claims. So a person who is able and available for work is not someone who is out because of a medical issue. Unfortunately, that means that you're not able and available for work. And unless we were talking about the COVID pandemic unemployment, if you are out due to COVID, that was an eligibility prong for the pandemic unemployment, but unfortunately, that's not the case anymore. And then you must search for work. The work search requirement was lifted for the pandemic. It has recently been put back in place. So claimants must continue to show employment security that they're searching for work. And then claimants must file weekly claims. So if a claimant doesn't file on time for their weekly benefits, then they won't be eligible to receive those benefits. So as an employer, what happens when an employee leaves or is laid off and files for unemployment benefits? You'll receive this notice of claim and verification request. You'll see at the top, it lists the claimant's address, it lists your employer name, your unemployment account number, and then it'll tell you that the claimant has applied for unemployment benefits. And this is the first step in responding to that unemployment claim. So all Employment Security asks is that you fill out this form, either online or send it in by fax or mail. And once you submit this form and you indicate the reason for the separation, you'll see the list of different reasons that start at the bottom of the first page and go well into the second page. Then Employment Security will send you what's called a fact-finding request. And they will have questions specific to that reason for separation. So that is when you get to tell Employment Security, this is why this person left. This is why that you believe that you don't think they're eligible for benefits, and so on. So once you go through this fact-finding process, unemployment will issue what's called a determination. So any decision that unemployment makes, and by the way, as I go through this, I will use Employment Security, unemployment, NHES, all to refer to New Hampshire Employment Security. That's the administrative body that administers New Hampshire's unemployment compensation program. So any decision that NHES makes will come in this type of form, and it'll say determination at the top, and then it'll tell you what type of determination it is. This is a sample determination of unemployment compensation. And so a determination of unemployment compensation determines the weekly benefit amount that the claimant will receive, if any. If there is an issue with eligibility, so either the claimant is not filling out their continued eligibility requirements, or there's an issue with their initial eligibility, you and the claimant will receive a determination of unemployment eligibility. And then instead of compensation, it'll say eligibility at the top. And so when you look at these determinations, it looks pretty daunting. There's this big top heading that gives you all of the information about the unemployment compensation and the employer and the claimant. But then there's a lot of words that sometimes make it hard for people to understand. And so I'm trying at this point just to get you familiar with what you'll see in these determinations. And so if you look, it'll say that this is a notice of determination. And then underneath it, the first paragraph tells you exactly what the decision that Employment Security has made and the reasons for that decision. It'll say, for example, you worked for this employer from this date to this date. You earned so much in wages. This does not meet the $1,400 minimum. Therefore, you're not monetarily eligible for unemployment. And then it'll give the citation to the specific statute. And so those may not be the easiest to read, but it's very important that you read that paragraph very carefully, as it tells you exactly what Employment Security has decided and why they've made that decision. And later on towards the bottom, you'll see that there's a place for interested parties. An interested party is anyone who, as it sounds, is interested in the unemployment claim. So that could be any past employers, the claimant. That's usually where you'll fall is as an interested party. And after the interested parties, the determination provides very important information about your appeal rights. Any interested party has a right of appeal. And so if you get any determination that you think you may disagree with, make sure to calendar the date by which you need to file that appeal. And we'll talk about this later, but that's normally 14 days after the determination date. And you'll see in the top right-hand corner is the determination date. And that, make sure that you know what that date is, because the date is not the date that you received this determination. It's the date that it was issued. And so if you receive determinations in the mail, that may be, that those 2 dates may not be the same. So how does a claim for benefits affect you? There are different ways that a claim could affect you. If the base period wages for the claimant are from a tax-paying employer or employers, the most recent employer's account will be charged for the benefits. If the base period wages are from a reimbursing employer, the charge for the benefits will be assigned to those employers, and those employers will therefore reimburse for that claim. If the weekly benefit amount is determined from a mixture of tax-paying and reimbursing employers, the charges will be split amongst those employers based on the ratio of wages paid from those employers. And so, as we talked about, the appeal process is something where employers and employees and claimants really have to deal with employment security, and that's kind of the quasi-litigation process of employment security. And so all appeals are first heard at the appeal tribunal unit. And I just put the information of the appeal tribunal unit in this slide. You will be getting copies of the slides, so don't worry about taking all that information down. And it's also available online as well. So there are multiple levels of appeal, as with any administrative body. The first level is the appeal tribunal hearing. That's where most appeals are held. And that body is very, very busy. It's still very busy from COVID, And so you will see some delay if you are trying to appeal a determination. Now, if you appeal a determination and you don't like the decision of the appeal tribunal, there's a second level of appeal. You can request to reopen the record of the appeal tribunal, and this is a request to the Commissioner of Employment Security. And you can only request to reopen the record for 3 reasons. If there was a mistake of law or fact, so you believe that the hearings officer at the appeal tribunal mistook some fact that you tried to put in the record or has the law wrong, those would be reasons for requesting to reopen. Another reason would be fraud. And the third would fraud, mistake. Those are the 3: mistake of fact or law, fraud. And then if you don't like the decision from the request to reopen, you can appeal to the appellate board. And if you don't like the decision from the appellate board, you can request for reconsideration. This is again another request to the commissioner. And if you don't like the decision for the reconsideration, you can then appeal directly to the New Hampshire Supreme Court. So requesting an appeal. An appeal must be requested in writing. It must identify the decision you are appealing and why you disagree. So if this is a determination of eligibility and you feel that this employee shouldn't be eligible for benefits, you would make the request in writing and say that you disagree that the employee is eligible for benefits. And you could give your reasons why, but you will also be giving the reasons why at the appeal hearing. If you file your request late, it must include the reason for your late filing. And so normally an appeal is not taken late unless it's for a good cause. And so you just have to explain to the appeal tribunal why it was late. It was lost in the mail. You've been dealing with an audit at your firm. There's some reason why you could not file it within the 14 days. Your request may be filed in person, by fax, by email, by an electronic form, or by mail. And again, it must be filed within 14 days of the date of the determination to be considered timely. Again, that may not necessarily be the date that you received the determination. So once an appeal is filed, you will receive a notice of appeal hearing. And you will not receive this specific notice until the appeal hearing is scheduled. And note that this is a sample, this is a real sample. So I have redacted all of the information, but you'll be able to see the general idea of what this notice will tell you. It'll list the docket number of the appeal, the method of the hearing. At this point, Employment Security is fully conducting hearings via telephone. And then it'll include the date, the time, the duration, the chairperson, the issue on appeal. That's really important because if you appeal the determination and you see that the issue is different from your appeal, you want to make sure you get in contact with the appeal unit to make sure that they have docketed your appeal in the correct manner. So once your appeal is scheduled and it's the date for and time for the appeal hearing, you want to know how the appeal hearing is going to go. So as I said before, it's all conducted via telephone right now, and it's what's called a de novo hearing. That means that the appeal tribunal, the AT, is not bound by your earlier determinations by Employment Security and here's the case anew. So that means that they're not going to say that because the employment security has already determined that this person should be eligible, I'm going to give weight to that determination, and instead of the evidence that I hear at the hearing. They're going to make really a redetermination, and determine whether or not that person should be eligible, or their weekly benefit amount should be changed, based on the evidence that's presented at the appeal hearing. Attendance at an appeal hearing, it's required if you want to be heard. So the appeal hearing is the only time when the hearing officer will take evidence. And so if you want to present evidence, if you want to be heard on the appeal, then you should attend the appeal hearing. If for some reason you either agree with the appeal, let's say a claimant files an appeal on eligibility, and you agree with that they should be eligible, or with whatever argument that the claimant is making, you may decide that it's not in your best interest to attend the hearing. That's perfectly fine. Again, it's only required if you want to be heard. So, but I would always suggest that you attend just so you know what's going on. And then the procedure at the appeal hearing. So what's going to happen is that the appeal chairperson will call each party. They will transfer everyone and conference everyone into one line. And then the chairperson will swear in those people who will be providing testimony under oath. And then what will happen is the chairperson will ask questions of each party. They'll normally start with the employer, get some basic information, the wages paid, the dates of employment, why the person separated from employment, and then they'll ask the claimant questions. And then if either party is represented by an attorney, then the chairperson will allow those attorneys to ask questions of both parties. I would just note that an attorney is not required to represent you at an appeal hearing. It may not even be necessary for certain cases. And a lot of times the claimants will not be represented by an attorney. And then at the end of the hearing, the chairperson, once they decide that they believe that all of the relevant evidence is in the record, they will close the record and allow any attorneys to say any closing arguments. After the appeal hearing, a written decision is issued within 7 to 14 days. And if you have not received a decision within 14 days, reach out to the appeal tribunal, because there are further appeal rights, as we talked about before, on these decisions. And so you may not have received a decision, but it may have been issued. And so you always want to make sure that you receive the decision timely, so that you can appeal timely if need be. And if you disagree with the decision, you may request that the commissioner reopen the record. So there are important appeal deadlines that you should consider for requesting a redetermination. So this is something a little bit different. This is separate from the appeal tribunal process. If you receive a determination, you can request within 60 days of the date of that determination that the certifying officer for good cause reconsider the determination. And so that's basically saying that you've issued this determination. I don't think it's correct. I think you need to reconsider it. This is not mandatory. And so the certifying officer may choose to do so. They may choose not to do so. If you disagree with a determination, it's always best to submit an appeal within the 14 calendar days in order to preserve your rights to appeal. If you request reconsideration of a decision of the appellate board or of the commissioner, that is a 20-day appeal deadline. So those are different than the normal 14 days for the other steps of appeal. And if you want to appeal to the New Hampshire Supreme Court, the notice of appeal must be filed within 30 days of the date of the decision. So some helpful resources. The Employment Security website has a lot of information. It's not very user friendly, so I've linked some helpful resources for you all that should help in providing you with some answers to your questions. The first is the frequently asked questions page. It is something that is very helpful, and it has a lot of different questions that you may not have even thought of that you needed answers to. The second helpful resource is the guide and the link to register as a new employer. And so that's the screenshot of the page I showed you earlier. The New Hampshire Unemployment Insurance System is the online system that helps you as an employer file all of your reports, register as a new employer, and there's also a link to the user guide as well. I'm also providing phone numbers to the benefit adjudication unit, your notice of claims forms, your notice of claim or determinations questions, and your benefit charges questions. Those phone numbers are staffed by people at Employment Security, and they should be able to answer questions for you. You will note that this was not an unemployment tax presentation. If you have questions about your unemployment compensation tax, you can follow the link to their web tax system, and then you can also mail tax and wage reports to New Hampshire Employment Security in Concord. There's in one of our next helpful resources, there is a guide to your tax benefits and how much you should be paying in taxes. I've also linked some business compliance resources. So the first is an employer's guide to new hire reporting. And then additionally, the form that you must submit for reporting new hires, as well as some telephone information, and then the link for reporting a mass layoff. If you have a mass layoff, that needs to be reported to New Hampshire Employment Security, as well as looking into what's required under the WARN Act. The New Hampshire Employment Security Employer Handbook is very helpful for employers. So the link at the top of the screen will provide you a link to that handbook, and it's much shorter than the statute itself. So it gives you a good overview of the things that you need to know as an employer. And it also provides some of those samples that we looked at earlier today to try to help you get more familiar with the forms and the different determinations that are used for employment security. Now we breeze through the presentation, and we hope to answer any questions that you may have. As Jim said, I do have some experience with employment security, especially during the pandemic. The firm was gracious enough to loan me out to New Hampshire legal assistance to help low-income claimants with their benefits and their claims for benefits and their appeals. So I've had a lot of experience in the COVID benefits, as well as helping employers in my current role with navigating the process of the benefit eligibility and the appeals. So Jim and I are happy to answer any questions you might have. The first question we have is, if an employee resigns to go to work for another employer and that job falls through, you mentioned that this employee would still be eligible for unemployment. Is there a minimum time frame on when this employee works for another company that may apply to this decision? So let me just pull up that statute for you. I mentioned that the RSA is very helpful If you are ever want to have some nice bedtime reading, if you just Google the employment security law and rule, you'll have a PDF of the statute and the rules. But let me get to that eligibility section.
As Abby is looking at that, I think it's one, we've had over 100 people participate in the presentation this morning. Abby, I think it was terrific information to provide, and going through that process, because even the appeals process to even an experienced HR professional can be confusing as they try to explain that to members of the C-suite. So I think that that's useful, and understanding how that works, because it's a different appeal process than you have at New Hampshire Commission for Human Rights or the Department of Labor and so on. So my understanding, Abby, had always been that the threshold for purposes of employment eligibility for unemployment benefits had been employment for 5 weeks at a minimum.
Yes, Jim, if you are disqualified for benefits, you must be employed for another 5 weeks in order to re-qualify for benefits. And I think what the section of the statute that I was referring to for benefit eligibility for someone who leaves their job for a bona fide job offer is that the job offer falls through, so they don't actually work for the second employer. And so you're eligible because you left for a reason that makes you eligible under the statute. It's not necessarily that you worked for the new employer for a number of weeks.
Yeah, and I think that the other issue is sometimes you have contributing employers. They look at one and they look at the previous employer as well. And I think that's where some of the HR folks could get a little confused too. Here's another question that came up, and that is, what happens, what are the consequences when an employer doesn't respond to requests for information from employment security when a former employee has applied for unemployment benefits?
So if the employer doesn't respond, a decision will be made without the employer's input, and it could be adverse to the employer. So if you don't respond, and the person actually left or was fired for misconduct on the job, for example, and the person, the claimant says, "Oh, well, I lost my job," and doesn't say anything more. Employment security, if you as the employer don't respond, could award them benefits, and then could charge your employment security account for those benefits.
So let me ask a follow-up to that then. Should for whatever reason, the employer not respond and benefits are awarded in the first instance, has the employer lost its appeal rights?
Not necessarily. The employer should always respond in the first instance. You can still appeal, but the appeal tribunal may take that into consideration that you did not respond, because you may have waived any challenges at that point. There is a waiver provision in the statute. Off the top of my head, I don't necessarily know if it's a strict waiver.
Let's talk about collateral estoppel. And lawyers like to throw out terms like that, and but there is an important provision in the statute with regard to that. So if there's a decision made by employment security with regard to someone's unemployment benefits, and it does, in the record, there's information regarding the employee's termination, issues with regard to misconduct, issues with regard to voluntary quit, and so on. Can you discuss briefly whether or not that the decisions of the New Hampshire Employment Security can be introduced as evidence in other tribunals, meaning beyond employment security, meaning Superior Court, District Court, or other agency tribunals?
So my understanding is that the appeal tribunal process. So the hearing itself, that's confidential. But the decisions, my understanding is that they can be introduced. And Jim, correct me if I'm wrong, but that not necessarily to the issue of liability, but it's just a decision. It's an administrative decision that has been made.
Yeah, I think that's an important distinction there. I think you're right. I think so. For purposes of what's called collateral estoppel, which means basically there's a decision and it will be introduced, and you basically are stopped, or there is a ruling of law that can be introduced in another proceeding. That cannot happen, because the body of law that Abby's been talking about, employment security and related unemployment benefits, that doesn't have any jurisdictional value elsewhere. However, sworn testimony during that process can be introduced for purposes of, well, under oath, he or she said the following, and that can be introduced. Now, that's what's called to impeach a witness for purposes of, well, under sworn testimony, this person has said here, but elsewhere under sworn testimony said this, and it gets to the truthfulness or veracity of the witness. So that is something that in part can be introduced, but the ultimate decision cannot be used to prove a legal issue in another proceeding under a different statute. I think that's effectively what so employers sort of get caught up on that, and they think, well, they don't worry about it because it can't be introduced elsewhere. But in fact, evidence and sworn testimony can be introduced. So that's where you have to be careful.
Yeah. So going back to the questions, for the first question about the job offer. So just so you know, that section is RSA 282-A:32, section 1, section A, and then subsection 2. And it says that the individual left work voluntarily without good cause, unless an individual terminates employment in good faith to accept better employment, which is to begin within a reasonable period. So it just it doesn't provide any type of time frame for when that better employment is to begin, just must begin within a reasonable period of time. The next question that we have is, should you attend hearings when you are not the last employer, but the claimant has wages that make you chargeable? You're an interested party, so you are welcome to attend the hearing. And if you are chargeable, if you are one of the chargeable employers, then it's always good to attend, because then you know what's going to happen. But for example, if the issue is eligibility, because of the reason that the person left the last employer, you may not have a lot to say. But it's always good to attend and to understand what's happening, because there's not going to be a transcript of these hearings. You're just going to get a decision. And if you're not there, you won't know why that decision might have been made, and you won't have any say in it. The next question that we have is, during the appeal session, do we need to resubmit the information already shared and submitted to employment security? That's a good question, and something that we didn't really talk about. If you appeal, or the claimant appeals, and you're going to an appeal hearing, you will want to submit any and all evidence. So evidence can be a number of different things. It's your oral testimony if you are the witness that's sworn under oath to provide testimony. It also can be physical evidence. So if the reason for the termination is codified in a letter that you had sent to the employee, that should be submitted as evidence. You don't need to necessarily submit your wage and hour documents that you might have previously submitted. But if the issue is the weekly benefit amount, then that may be something that you would want to submit. And any kind of physical evidence, documents, recordings, anything that you want the chairperson to take into consideration at the appeal hearing should be submitted at least 5 days prior to the hearing, and submitted via email or mail. to the appeal tribunal unit. And you should also provide copies of any of those pieces of evidence to any other interested parties. If there's another employer, or if the claimant is an interested party, you should provide those copies. Are the decisions of the tribunal confidential? Can they be shared with witnesses? Well, if you had a witness that was at the decision, that was at the hearing, I don't see why you could not tell them what the decision was, because they participated in the hearing. But anything that's related to your employees and their benefits, their wages, any of their information, I would try to keep that as close as possible, as confidential as possible, as you do with any of your employees' records. You really don't want any of those decisions, any of that information to be spread, just because, just to keep the confidences of the people that were involved in the decision and the process. The next question is, as an employer, is there a way to see who is receiving compensation and the amount? My understanding is that you will receive the determinations of who is receiving their unemployment compensation and what amount they're receiving, because you're either going to be reimbursing for that amount as a reimbursing employer, or your unemployment tax account is going to be charged. So you should be receiving a determination as to those specific amounts in real time. You may be able to see that online on your portal, but I am not completely sure.
You can through the portal, and you can also see through your HRIS system whether or not someone's currently receiving benefits or how much they receive.
Mm-hmm. Those are all the questions that we have.
Well, I had another one, Abby, and I'm just sort of blanking on it here. A junior senior moment here, but yeah, gosh, I know. Disqualifications. Let's talk about those just for a quick second. Whether it's a voluntary quit,
yeah,
and what the department looks at for purposes of what is truly voluntary, and the other is with regard to describing what is misconduct for purposes of a disqualification.
Mm-hmm. So a voluntary quit is voluntary if it's what's called without good cause. And now this is one of those defined terms in the statute. And so good cause in New Hampshire must be, again, we're going to another defined term, which just makes this so unhelpful for people who aren't familiar. So good cause must be attributable to the employer. And that is another, as I said, specific defined term. And it means a certain thing, and I'm just pulling it up. Attributable to the employer means that it was not the employee's fault that the employee had to leave. For example, if an employee says that they were constructively discharged, that would be a reason for something to be attributable to the employer.
So pausing on that for a second, Abby. So for the folks watching today, a constructive discharge is what?
Is basically when the employee says, I had to leave my job because I felt that I was essentially unable to do my job because of the employer. So I felt that I was discharged because of how I was being treated by the employer or by other employees.
Yeah, and I think I think the department applies a reasonable person standard. No reasonable person could be expected to continue in this job. So you probably had those employees out there that said, I felt like I had to leave, and there really wasn't a good reason for that, or they may have been, but it's a reasonable person standard. Let's
Yeah.
talk about the other one, which is misconduct, because that has many different meanings. So, but for purposes of unemployment, what's the threshold? What's the standard?
So there's a couple of different things. Unemployment defines gross misconduct as an unemployed individual who has been discharged for arson, sabotage, felony, assault, which causes bodily injury, criminal threatening, thefts, and all of those things that where those acts are connected with the work.
And we're not talking about what happens at the holiday party or right after, which we're talking about the other gross misconduct, right?
Yeah. And then someone who is someone qualifies or is disqualified under misconduct if they were intoxicated at work, if they were under the influence of drugs at work, if they stole. I'm just trying to see if there's anything else. Yeah, so the general statement under the statute is that if you are discharged for misconduct connected with your work, if so found by the commissioner, you are disqualified.
And my understanding of that always had been, Abby, that if you violated a work rule, serious violation of a work rule under those categories or related categories, and you knew or should have known by violating that policy, you would be terminated.
Yeah.
Sometimes these cases, from our experience, turn on, did the employee know of the rule, or should he or she have known about the rule?
Yeah.
And also some of the stuff is just so egregious, we don't have to write everything down.
Yeah.
And it's, yeah. Well, good.
So we just have one last question. Were employers charged for COVID unemployment? So if someone received federal pandemic unemployment through any of the programs, it would have been charged to the unemployment compensation fund, which is where the money from the federal government went into. It's basically the bank account that money went into and then was dispersed by employment security. If someone received state unemployment during COVID because they were laid off for some reason that made them eligible for state unemployment instead of the federal benefits. If it was related to COVID, it may or may not have been charged to the fund. If it was unrelated to COVID, it would not have been charged to the fund. It would have been charged to your normal accounts. But you would have been, when you receive those determinations of unemployment compensation, it'll say where the charge is going. So when people were receiving benefits for COVID related loss of work, it said benefits charged to the unemployment compensation fund. If the benefits weren't charged to the fund, it said benefits charged to the charging employer or to the reimbursing employer. Those are all the questions that we have, Jim.
Well, Abby, again, awesome job going through this program and going through these materials and answering the questions. Truly appreciate it, and hope you folks did too. Again, we've got more than 100 people paying attention this morning. The materials, joining us this morning rather, but the materials are available, and again, the credits are there, and so you don't have to go through any hoops in that regard. Kelly and Liz in our business development section will be sending an email to you with information with regard to the SHRM credits, but also a PDF of Abby's materials, which I think are exceptional. And I actually recommend that HR professionals keep them on their desk and at the ready, or even on their desktop, just to answer them, or as Abby said, as a sleep aid. But I think, all kidding aside, I think it's actually very useful to explain the process, especially if the HR professional has to explain it to a new manager or to someone in the C-suite as to why they're being charged for the person's unemployment benefits. So very useful, very helpful, and we appreciate, Abby, you taking the time this morning. So thanks, folks. Thanks for joining us. And we look forward to you joining us at our next HR Exchange event in June. But in the meantime, remember, there are only 20 seats or so remaining in our annual employment law seminar on May 26th, and we encourage you to register for that. Hopefully today, if you can. Those seats are going fast. Thanks so much and have a great day.